Section 24, Presumption of Consideration. So every negotiable instrument is deemed prima facie to have been issued for a valuable consideration, and every person whose signature appears thereon to have become a party thereto for value. So what do we mean by consideration? In your oblicon, what do you mean by consideration? Remember the three essential elements of a contract. We have COC. C stands for consent, O for object, and another C for consideration or cause. So consideration means an inducement to a contract. That is the cause, the price, or the impelling influence which induces a contracting party to enter into the contract. So like all other contracts class, a negotiable instrument must have a consideration or a cause. Remember that it is not necessary, however, that the consideration be expressly stated in the instrument because, again, remember this, there is a presumption of consideration. If there is no consideration, okay, Article 1409 of your Civil Code says that it is a void or inexistent contract. So again, that's one of the essential elements of a contract. If there's no consideration, then the contract is non-existent. It is void because one of the essential elements is not present, and that is cause or consideration. Even though there is a parallel provision, 1354, of your civil code also, although the cause is not stated in the contract, it is presumed that it exists and is lawful unless the debtor proves the contrary. So those are the parallel provisions of Section 24 of the NIL. We have 1409 of the Civil Code. We have 1354 of the Civil Code. So looking at it under Section 24 of the NIL, okay, you need not mention cause or consideration class because, again, there is a presumption that a consideration exists. However, this presumption class is not conclusive. This is only a disputable presumption. So in the case of Martinez versus Rodriguez, it states there that absence of consideration is a personal defense. In civil code, illegal consideration makes the contract void. So that's in your oblicon. However, in NIL, illegal consideration is treated merely as a personal defense not available against a holder in due course. So only parties involved in the illegality and subsequent parties who are not holders in due course can be adversely affected by such defect, because this one, absence of consideration, is only a personal defense against a holder in due course. Hence, it cannot be set up against a holder in due course. So that is Section 24 of NIL. Section 25. Value. What constitutes? Value is any consideration sufficient to support a simple contract. An antecedent or pre-existing debt constitutes value and is deemed such whether the instrument is payable on demand or at a future time. So remember, under Section 25, a valuable consideration need not be adequate. It is sufficient if it is a valuable one. Section 26. What constitutes holder for value? So here comes the first type of holder class that you will encounter under Section 26. This is so much part of Section 52 and Section 62. So kindly memorize this section. Section 26. What constitutes holder for value? Where value has at any time been given for the instrument, the holder is deemed a holder for value in respect to all parties who become such prior to that time. Okay, so one who has taken a negotiable instrument as collateral security for debt has a lien on the instrument. Okay, for example, M makes a promissory note for 1,000 pesos to the order of P, who pledges it to A to secure payment of P's debt of 800 pesos. The note is endorsed and delivered by P to A. Okay, in this case, A is a holder for value to the extent of 800 pesos, which is also the extent of his lien. On the maturity of the note class, even if the debt of 800 is not yet due, A may recover the full amount of 1,000 pesos, holding the surplus for P, the pledger. Kasi si P ang nag-pledge ng note, okay, worth 1,000 pesos. So if M has defenses against P, the endorser, such absence or failure of consideration, then A can collect only 800 pesos on the note, even if he is a holder in due course. As the note in the hands of M is void, all that sought to be recovered by A is the amount due on the loan. So supposing the amount of the instrument is 700 pesos only, then A is a holder for value for the full amount of 700 pesos and is entitled to recover to that extent, no, 700 pesos. So in the case of Caltex versus Court of Appeals, the Supreme Court said that where the holder has a lien on the instrument arising from contract, he is deemed a holder for value to the extent of his lien. As such holder of collateral security, he would be a pledgee, but the requirements therefore and the effects thereof, not being provided for by the negotiable instruments law, shall be governed by the Civil Code provisions on pledge of incorporeal rights. Section 27. When lien on instrument constitutes holder for value. So where the holder has a lien on the instrument arising either from contract or by implication of law, he is deemed a holder for value to the extent of his lien. So remember, class, that a holder for value is one who has given a valuable consideration for the instrument issued or negotiated to him. So a holder of a negotiable instrument, is presumed to be a holder for value until the contrary is shown. Again, that is a disputable presumption lang. A holder who has not given value for an instrument obviously, okay, will suffer no loss by being unable to recover from the primary party in the event that the latter has a personal defense assertable by him. So for example, M issues a note to P, the payee, without consideration. P also without consideration endorses it to A, who with value endorses it to B. So under section 26, okay, B is deemed a holder for value not only as regards A, but also as regards M and P. Now, if B is a holder in due course, he may enforce payment for the full amount of the note against M, P, and A. What if B is not a holder in due course? Then M can set up the defense of absence of consideration. Now suppose, class, in the same example, B negotiates the note to C by way of a gift. Okay, so who is C in that example? Well, C is a holder for value within the meaning of section 26 as against M, P, and A. Why? Because M, P, and A become parties prior to the time when the value was given on the note by B. Section 28. Effect of want of consideration. Absence or failure of consideration is a matter of defense as against any person not a holder in due course, and partial failure of consideration is a defense pro tanto, whether the failure is an ascertained and liquidated amount or otherwise. Pro tanto means for so much or proportionate. So class, we have to differentiate absence of consideration and failure of consideration. When we say absence of consideration, it means a total lack of any valid consideration for the contract. So in consequence of which the alleged contract must fail. Okay? Failure of consideration naman means the failure or the refusal of one of the parties to do, perform, or comply with the consideration agreed upon. So in other words, something was agreed upon as consideration, but for some cause, such agreed consideration failed to materialize. For example, M makes a promissory note to P in payment for a parcel of land, okay? Then P failed to deliver it to M because he sold it again to X, who in good faith registered the sale. So here there is failure of consideration so that P cannot recover from M. If only two-thirds portion of the land was delivered, there would be a partial failure of consideration which would bar recovery only pro tanto. So hence, P in that example could recover only two-thirds of the note as M is not liable to the extent of one-third, which is the price of the undelivered portion. Let's talk about accommodation party. Okay, so section 29 of the NIL defines an accommodation party as a person who has signed the instrument as maker, drawer, acceptor, or endorser without receiving value therefor, and for the purpose of lending his name to some other person. So class, as gleaned from the text, okay, from that provision, an accommodation party is one who meets all the three requisites. Okay, what are those? First, he must be a party to the instrument. Okay, signing as what? Signing as a maker, a drawer, an acceptor, or an endorser. Second is that he must not receive value therefore, okay, for the negotiable instrument. And lastly, he must sign for the purpose of lending his name or credit to some other person. So those are the three requisites, okay, before one becomes an accommodation party. So here, an accommodation party lends his name to enable the accommodated party to obtain credit or to raise money. Okay, so we have here accommodation party and the accommodated party. The accommodation party receives no part of the consideration for the instrument, but remember this, the accommodation party assumes liability to the other parties thereto. So the accommodation party is liable class on the instrument to a holder for value even though the holder at the time of taking the instrument knew him or her to be merely what? Merely an accommodation party, as if the contract was not for accommodation. Okay, for example, B is badly in need of 500,000 pesos. However, no one is willing to lend money, no, to B because B has no credit. Now M has an excellent credit within the banking community, and M is a very close friend of B. So M makes and signs a note as maker with B as payee. So in signing the note class, M did not receive anything from B and was done simply to help B. So B here is the party accommodated while M is the accommodating party or the accommodation party. Tapos si B ang accommodated party. Now B then endorses the note to XYZ Bank, which upon seeing the signature of M discounts the note. So here the note is an accommodation note. Okay? So in this case, okay, B cannot enforce the note against M. Should B pay the bank because B gave no consideration to M and he was merely accommodated by M. Okay, to continue, we have the liability of accommodation party. So remember this, that an accommodation party is liable to a holder for value even if the latter knows him to be only an accommodation party. However, okay, he is not liable to the party accommodated. Now, in the case of Garcia versus Llamas, okay, the Supreme Court said that if a person signs a note to lend his name to the transaction in order to help another, as when he signs as a co-maker and the instrument is not negotiable, then the person who lends his name cannot avail of the protection of the NIL and claim that he is merely an accommodation party because, remember this, the said law applies only to negotiable instruments. Kining section 30, okay? The liability, section 29, sorry, section 29, pertaining to accommodation party. So meaning, a non-negotiable note is covered by the Civil Code. So section 29 applies only to negotiable instruments. Now, what about the relationship between the principal and the surety? Same ba na siya sa relationship ng accommodation party and the accommodated party? The answer is yes. Okay? The relation between an accommodation party and the accommodated party is one of principal and surety. The accommodation party being the surety. Ang principal, si accommodated party. So, as such, he is deemed an original promissor and debtor from the beginning. He is considered as the same party as the debtor in relation to whatever is adjudged touching the obligation of the latter, since their liabilities are interwoven as to be inseparable. Although class, a contract of suretyship is in essence an accessory contract, diba? Or it is a collateral to a valid principal obligation, the surety's liability here to the creditor is immediate, primary, and absolute, meaning he is directly and equally bound with the principal. So the obligation is solidary. Still remember, oblicon, we have joint obligation, we have solidary obligation. Kanang solidary obligation, one for all for one, that applies to the relationship between the accommodation party and the accommodated party, because it is same with the relationship between the principal and the surety. Okay, so as an equivalent of a regular party to the undertaking, a surety becomes liable to the debt and the duty of the principal obligor even without possessing a direct or personal interest in the obligations, nor does he receive any benefit therefrom. Okay? So, under the law, upon the maturity of the note, a surety may pay the debt. Tama. Kasi a creditor may demand full payment either from the principal or from the surety. Kasi nga, the relationship, the obligation is solidary. Okay? So, upon the maturity of the note, a surety may pay the debt, demand a collateral security if there be any, and dispose of it to his benefit, or, if applicable, subrogate himself in the place of the creditor, with the right to enforce the guarantee against the other signers of the note for the reimbursement of what he is entitled to recover from them. So since the liability of an accommodation party remains not only primary but also unconditional to a holder for value, even if the accommodated party receives an extension of the period for payment without the consent of the accommodation party, the latter is still liable for the whole obligation. And such extension does not release him because, as far as a holder for value is concerned, he is a solidary co-debtor. Okay? Kasi nga, solidary ang obligation. Okay? Between the surety and the principal, between the accommodation party and the accommodated party. So it is a recognized doctrine in the matter of suretyship that, with respect to the surety, the creditor is under no obligation to display any diligence in the enforcement of his rights as a creditor. Okay, let's differentiate the two, accommodation party versus regular party. The accommodation party signs the instrument without receiving value, therefore, while the regular party signs the instrument for value. Accommodation party signs the instrument for the purpose of lending his name to some other person. However, the regular party does not sign for that purpose. Accommodation party may always show by parole evidence that he is only such, okay, that he is only an accommodation party. However, a regular party cannot disclaim or limit his liability as appearing on the instrument by parole evidence. Okay, I'm talking about evidence na. Wala pa mamunoy evidence, no? Accommodation party cannot avail of the defense of absence or failure of consideration against the holder not in due course, but a regular party may avail of the defense of absence or failure of consideration against the holder not in due course. And lastly, an accommodation party, after paying the holder, the accommodation party may sue for reimbursement the accommodated party. Okay? However, a regular party may not sue any subsequent party for reimbursement.